May it please the Court, my name is Elisa Smith and I represent McKeel Harvey. This case is on appeal from two orders by the trial judge. The first, the order denying Mr. Harvey's sworn motion to dismiss, and the second, the order revoking his probation. Both orders should be reversed because the state failed to produce sufficient evidence to show that Mr. Harvey constructively possessed the marijuana that was found secreted in a shoebox in the master bedroom of a jointly occupied home. The first order, the order denying the motion to dismiss, is reviewed by this court de novo. There was no traverse filed by the state, so in all actuality, the court should be reviewing this case based upon only the four corners of the motion itself. But even if the court were to consider the evidentiary hearing, the judge did a joint evidentiary hearing here, the only additional evidence that was introduced at that hearing was the testimony of the probation officer to say that Mr. Harvey resided in this residence, which he denied. But in
let's look, if I may, Ms. Smith, let's look at the whole, take into account what was presented in the evidentiary hearing, the facts. When I guess the probation officer came to a conclusion that he must have resided there. But let's look at the facts that led him to this conclusion. There was a bedroom, I guess it was a master bedroom, and there was evidence presented that I guess he had there's pictures of himself around, the Polaroid pictures of himself in the master bedroom. There's also evidence that he also had clothing in the bedroom. And I guess for me, the mail, that was the mail that was found there. And also, what I think is rather impressive is the fact that this is the address that he provided to probation. So help me out, why should we discount any of these?
Oh, I'm not arguing that we should discount that evidence at all. The argument really on appeal is that even if Mr. Harvey was utilizing this bedroom, that he did not have exclusive use of the bedroom, that this bedroom was accessible by others. Clearly, this was Mr. Ward's home. The police were there to arrest Mr. Ward, and I guess when they were executing the warrant, he ran into the home, and then he opened the door and they found drugs in the living room. And Mr. Harvey...
Bad luck, wouldn't you say?
Yeah, probably a series of bad luck.
Yes.
But Mr. Harvey was located in the master bathroom, and so then they executed a search warrant and found the secreted drugs. What really the argument on appeal is that the sworn motion to dismiss does not provide, the prosecutor didn't provide that this was an exclusive use. The court in this district and others has held that if premises are accessible by others, this court in Ford and Santiago and many other cases, if a residence or premise is accessible by others, it's not exclusive to that individual, then the state doesn't get the inference of possession or constructive possession. The state has to demonstrate that Mr. Harvey had knowledge and dominion and control over the drugs that were secreted, that were hidden in a shoebox, and apparently on a wall of shoeboxes. Mr. Harvey had recently been released into probation, so he could have only been at this home for a few days. There is nothing linking Mr. Harvey to the hidden drugs. This case is about drugs that are hidden in this bedroom. And cases with facts far more incriminating than these, this court has held that that is insufficient. For example, in the Santiago case decided by this court in 2008, there was a bedroom that was Mr. Santiago's, but also perhaps his girlfriend's. Other people had access to it. And the evidence was secreted in a lockbox in a dresser. And there was also drugs found in men's pants.
And shoulder pads.
And football shoulder pads that clearly would not have belonged to a young woman. But this court held that the evidence was insufficient to demonstrate knowledge because there was no evidence that linked Mr. Santiago individually to these drugs. There were no fingerprints, there was no statement, those kinds of things. I think that's much more incriminating than what we have here. There's nothing that suggests that Mr. Harvey knew about or controlled these drugs that were found during the execution of a search warrant hidden in the shoebox on the top of other shoeboxes. And even with only a prima facie showing, and even with the most favorable construction to the state, there has to be some evidence linking Mr. Harvey to these secreted drugs, or else what we risk is that mere proximity alone to hidden drugs is sufficient to prove constructive possession. And there are many, many cases that hold otherwise.
In Santiago, how many people were at the house when the police officers arrived with the warrant? There was a bunch outside, right? There was a bunch inside, and the bedroom had Mr. Santiago's name etched in glass with Ashley, if I recall correctly.
Yes, I believe that's the case.
So do I, since I wrote Santiago.
Mm-hmm.
Yeah, it was 2008 when it was decided.
I was here that far back.
Yes, so was I. I actually represented Mr. Santiago in another case. But even with all of that, that linked him to that bedroom, this court found that that's not sufficient because there has to be a link to the actual drugs. If they're concealed.
Between having joint possession of a bedroom, and having exclusive possession of that bathroom in a bedroom, pardon me. This gentleman got found in the bathroom that belongs to the master bedroom suite, and that's why I've been saying bathroom. Let's call it the bedroom. Does it make a difference if that's an exclusive room for that person, based on the evidence?
Not if it's accessible to others. This court in Ford, in another violation of probation case, found that if there's an apartment and a studio, in that case, there were 2 different rooms.
Now, is Ford the person that ran from house A to went to house B, the adjoining house, and they found him inside peeking through the window?
I don't believe so. I believe that was another case. Ford is the case where they did a search of an apartment that he shared with his girlfriend. They didn't think there were drugs in the house.
That was a recording studio.
And the recording studio. And ironically enough, that was another case where there was drugs hidden in shoeboxes. Apparently this is very popular. But they said because there was nothing linking Mr. Ford to the actual concealed drugs, and it was accessible. It's not just exclusive. It's if the room, the home, the premises, the car, here it's a home, is accessible by others, there has to be some independent proof. The cases rely...
In Ford, did the defendant offer a hypothesis of innocence in this circumstantial evidence case from the girlfriend testifying, those were my drugs, and I hid him in his suit pocket because I know in other words he suits when he goes to funerals? Is that the right case?
I don't think so.
Okay. I read so many of them.
Yeah, and they all begin to blend together. I don't think that's this case. I don't think there was a hypothesis of innocence. I think that it was about whether there was constructive possession. In that particular case, the court, because it was
You're
a
right,
violation
that was Weidner.
Weidner. Yeah, there's a lot of cases that dealing with constructive possession. And they say if it's not actual possession, that there needs to be independent proof, whether it be statements, fingerprints, or the like. The cases cited by opposing counsel, Reese and Holland, are cases that are easily distinguishable. Those are cases where there was an allegation of exclusivity, but the drugs in those particular cases were in plain view. In other words, I believe it was Reese, it was Holland. They were in the bedroom. The woman was in the bedroom, and she tried to make the argument that, her daughter had access to that room. The problem for Ms. Holland is that the drugs were not only in her bedroom, but they were strewn about in plain view. And so in that situation, the prosecutor is entitled to the inference that the person had knowledge of and perhaps even control and dominion over. Same thing with Reese. In Reese, they were going to execute a warrant at her home. She saw the police coming. She shut the door. She ran to the bathroom. The police came in with the warrant and found her in the bathroom with the drugs in the toilet. Under those set of circumstances, the prosecutor is entitled to the inference that they had dominion and control as well as knowledge. But there can't be an inference when there's nothing linking someone to concealed drugs. At that point, it would be mere proximity. And that's the case under whether it's the sworn motion to dismiss or under the competent substantial evidence standard. There has to be more. And only to address one other point that opposing counsel made in her brief with regard to the violation of probation hearing, the trial judge here made no factual findings. Judge Ficarota just denied the motion and then denied then revoked his probation without making any findings whatsoever. On appeal, opposing counsel is arguing, essentially piggybacking on what the prosecutor below argued, and that was that somehow, because there were these drugs in the living room that were in plain view, that presence imputed the knowledge of the secreted drugs to Mr. Harvey. Two things. One, Mr. Harvey was not charged with the drugs that were found in the living room area, the ones that were in plain view. And two, this court has already, again in Santiago, rejected that kind of a legal analysis, that just because a defendant may have knowledge that there are drugs in plain view does not impute the knowledge of all of the drugs that are secreted within a home, that that individual had knowledge of or control and dominion over. Any other decision in this case holds Mr. Harvey responsible for simply being in a room where perhaps someone else secreted these drugs. And under either standard, the prima facie showing or competent substantial evidence, both orders should be reversed. And Mr. Harvey should be released from prison and given time credited toward his probation. Thank you.
Thank you.
Good morning. My name is Alvin Martin, and I represent the state of Florida, appellee in this case. First, I'd like to address the motion to dismiss. In this case, what we have is a gentleman that was inside an ensuite to a master bedroom that was in his sole exclusive possession. Everything in that room was his. We're talking about clothing that he admitted were his. We have mail that was in his name in the room, and photographs that he also admitted were of him in the room. Secondly, what we also have is his own statements to officers when they came in that this was his address, this is the address he provided to probation. He told the officer at first, and I'll quote it for the court, that he initially did not want, that the people that he was living with did not want the state to have that address. Then he stated that he was actually living with his girlfriend as well, but he didn't want to give her address because he didn't want the police coming there. These are all circumstances that indicate not only guilty knowledge, but dominion and control over these drugs. And added to that is the fact that when officers came into this home, in the common areas were found cocaine and marijuana in the common areas, such as the kitchen and the living room. All of this put together, it makes these disputed facts. And at this point in the proceedings, all the state has to prove is a prima facie case. All these facts put together make it a material dispute, and therefore the state asserts that it passes the test for a motion to dismiss. Secondly, as to the violation of probation. The violation of probation also is only a preponderance of the evidence standard, which means the state need only prove by a greater weight of the evidence that Mr. Harvey in this case constructively possessed these drugs. This is also proven by, of course, all of the testimony that came out in the violation of probation. Mr. Harvey actually testified that the only reason why he was in the house at that particular time was to use the restroom, that he didn't really live there. But everything shows the opposite. Therefore, again, it is up to the court in its discretion to decide whether he has committed a violation of probation, and the court found so. Therefore, I ask this court to please affirm the findings below. If the court has no further questions.
Might as well let you have at least one before you sit down.
Okay.
We'll see if we can get one case that's pretty close. There's a case out of our court called Diaz, written by Judge Wally, if I recall correctly, and we have the same trial judge. We have the same thing of a shoebox in a closet. How does the state distinguish that case? And I'm only asking you to speak to the direct appeal from the original charge, not the violation of probation.
Okay. I do not remember the Watley case, Your Honor.
Okay. The
at this point?
officers had a 3-bedroom house in Diaz. They testified they were able to determine whose bedroom. They go in the bedroom, and I guess there's a shoebox up pretty high, and they found drugs. And as has been pointed out, a lot of people like to hide them in their in their closet. I don't know why, but they do. And I guess the only difference that I can tell in that case is the defendant in that case testified that the drugs were given to him by somebody he knew from the street called Chicago or some nickname. Now, is that a significant factor, or what? But I figured it's pretty close. It's Hillsborough County, same judge.
It seems very
shoebox, but there's a shoebox.
right. It seems very close, and I'll point out to the court
Actually, the only thing to add to that, I think the facts in that case, the shoebox was found in the closet, I think.
You know, it's way high, and this
Way
guy,
high.
the defendant, is very short.
Right.
Apparently.
Right.
I mean, I'm trying to figure out, all these cases go by facts, but I think Judge Kusown, it was high up.
In this case, the shoeboxes, the testimony was that they were up against a wall. There was about 20 of them, and this one was on top. I would counter with the Holland case that is also out of this court, which is a case where Miss Holland lived with her daughter in a 3-bedroom house. There was no testimony about other drugs throughout the house, and there was no testimony either about
Well, let me ask you this, if I may, because you keep making reference to drugs found in the other house. As Ms. Smith said, her client, he was not charged with that drug that was found in Plainview, correct?
No.
All right, so how does that parlay into, shouldn't we just focus on the drugs that he's been charged with, and the whole issue before us, does he have dominion control of the drugs that were found in his bed, in that bedroom, in that shoebox?
I would say yes, partly, and with the reference to the drugs found throughout the house, they were in common areas. They weren't hidden. They were out in the open. Therefore, to get to this master bedroom and master bathroom, they were in the common areas where appellant would have to pass through. So therefore, there was knowledge there of other drugs in the home. Secondly, in this case, you also have the testimony. You're looking at all the totality of the incriminating circumstances. If it was in some locked room, in a locked bedroom that he had absolutely no access to, then that's of course a different scenario. Also, I would ask the court to look at the fact that, of course, the prosecutor can charge what they feel that they can prove, obviously. Maybe because, I can only speculate, maybe because the common areas are joint, they could not show that he actually had some type of dominion and control at that time because he was inside the master bedroom in the master bathroom of this master bedroom.
We're talking about proximity. Mr. Ward wins that award.
That partly
He's
proximity.
opening the door to the front room, and that's where the drugs are. So if we're talking about proximity of the two, he's closer.
He's closer. However, to get to this master bedroom, you have to pass through, that's why they call it a common area, is that's where he would have to go through to get to this room. Not to mention, again, there's nothing in the room. The entire room, all the facts show that this is his room.
So you're taking the position that he has exclusive possession of that
The bedroom. And again, we must look at the entire circumstances, all the incriminating statements and incriminating circumstances here. And that's what the Holland case and I believe the Reese case both refer to, is the incriminating circumstances surrounding the incident, what occurred. Are there any further questions? Thank you. I would ask that you please affirm the judgments below.
Just very briefly, I think the distinguishing facts, which I've already highlighted, is that this isn't a Plainview case. These were secreted drugs. Even if he had exclusive use of the bedroom, which the facts don't necessarily support, it doesn't mean that he had ownership over the shoeboxes or he had ownership, dominion and control, or knowledge, for that matter, over the drugs within the shoeboxes. Any decision that should hold that that's sufficient evidence, this court would have to actually overrule most of its precedent in Diaz, Weidner, Santiago, Ford, and the like, because that's all the evidence that is here. If this was in plain view, or if he had made a statement that those were his shoe boxes, I probably wouldn't be here. Then there would be sufficient evidence, But
Ms. Smith, if I may, because Diaz, when I know they've mentioned about Diaz, wasn't Diaz also a little bit different in the sense that the facts there showed that it was jointly occupied between the defendant and his girlfriend. So it was just not unlike this case where it could be argued based on the evidence that perhaps he had exclusive possession of the bedroom. Would that make a difference?
Not in this case, Your Honor. In this case, it's clear from this record that Mr. Harvey had only been living there, if he had been living there, and we can concede he was, for several days. He had just been released from jail and onto probation, so he was there maybe 3 or 4 days, and he was staying there. 1, 2, the record shows during the testimony that when the police officer was asked on page 153 through 157, whether there were any women's clothing in there, the officer said that he didn't know. There was no testimony about the location of the clothing or the pictures, where these were located in the room. They could have just been thrown on a bed temporarily.
Okay, let me ask you this. Would it have made a difference if perhaps his pictures of himself or mail was right next to where the drugs were found? Would that change your analysis in any way?
If the drugs were in plain view, yes. If they were secreted in a shoebox, I would still argue no under Santiago. In Santiago, they found the drugs, at least some of the drugs, there were many drugs in that house, some of the drugs in a lockbox, and in the lockbox there was, I think, an identification card, a receipt, and then some other piece of evidence in that lockbox with those drugs. And this court held that that was insufficient to prove knowledge and control over those drugs. Far more incriminating than what Mr. Harvey has here. He's just in a room where there happens to be a shoebox full of individually packaged marijuana.
Would you agree that Ford and Santiago and Weidner all talk about a jointly occupied premises?
Yes, they all talk about...
In this case, on the motion that we have before us, all we know is the record establishes that only the appellant occupied that bedroom. Is that a distinguishing fact from those cases?
No, I think the jointly occupied residence is that Mr. Ward lived there as well. It's the residence that's jointly occupied, that there were other people accessible. This court also, in many of the cases, including Ford, highlights the accessibility. If a room is being used but is accessible by others, that is also a factor that needs to be considered in a constructive possession analysis. Thank you.
Thank you both.
Thank you.